benefit from a brief summary of the facts of this case?
No, just pull out the relevant bits.
Lord Hoffman was heavily related to Amnesty International, and the decision to deny the extradition of Senator Pinochet was seen as a result of this affiliation to be biased. And therefore, if a party has a certain affliction to the case before him, he should not be able to cast judgment over the case, but rather the decision be made by individuals who are independent. Applying this to the instant case, as the initial magazine article which led to Mr. Wacker's decision to punish and ultimately expel the appellant, results in the ruling being either fair, independent or impartial, and therefore contrary to Section 6 of the Convention, and the appellant should be granted a fair and impartial tribunal in order to assess whether the decision to expel him was in fact fair based on the circumstances. May I proceed with my second point of submission?
Yes, please do.
Article 3 of the European Convention on Human Rights states that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. In the present case, the fact that the appellant, a sixth form pupil, would have to endure 4 strokes of the cane in front of the whole school at morning assembly would reasonably be deemed to be classed as a degrading form of punishment. Furthermore, may I direct your Lordship's attention to the Education Act 1996, and more specifically to Section 548, and at tab 7, page 2 of your Lordship's bundle. With your permission, may I proceed?
Yes, please do.
Section 548 states that corporal punishment given by or on the authority of a member of staff to a child for whom education is provided at any school cannot be justified in any proceedings. In the instant case, as the statute clearly outlaws the use of corporal punishment in schools, either public or private, the respondents are therefore liable to adhere to Article 3 of the European Convention on Human Rights. The fact that this method of punishment has been outlawed in England and Wales clearly means that to administer this treatment to another person is deemed to be a form of inhuman treatment.
How would you argue that there was no actual caning? This talks about corporal punishment given by an authority to a member of staff or to a child to whom was educated. In this scenario, no administration of cane has been used.
In the facts of the scenario, it states that Mr. Wacker be restrained from caning Billy on as a result of it infringing his Article 3 right. So therefore, if he was to be reinstated after gaining his Article 6 right to a fair trial, the caning would infringe his Article 3 right to not to suffer torture, and therefore this legislation would refer to a future to be restrained from him, as it's an inhumane form of punishment. Does that answer your lordship?
Yes, thank you.
My lordships, I would now like to direct your attention to the case of Tyra and the United Kingdom as heard in the European Court of Human Rights in 1978 and reported in the European Human Rights Reports, Volume 2, page 1, and at tab 8, page 1 of your Lordship's bundle. My Lordships, are you familiar with the facts of this case?
Yes.
The court held at page 1 that a punishment would be degrading and in breach of Article 3 where a person was humiliated, not simply by his conviction, but by the execution of what that punishment where the humiliation or debasement attained at a particular level which exceeded the usual humiliation inherent with the punishment generally. In the instant case, the fact that the appellant has clearly threatened with corporal punishment in front of the whole school at morning assembly would amount to degrading treatment if the act had been performed. This is because the appellant would be subjected to humiliation on an excessive scale compared to a punishment being carried out in private. Your Lordships, if I may, I would now like to direct your attention to the case of Campbell and Cousins, the UK, as heard before the European Court of Human Rights in 1982 and reported in the European Human Rights Reports, Volume 4, page 293. Are your Lordships familiar with the facts of this case?
No, but it's obviously keep it relevant.
Would you like a benefit from a summary, a brief summary?
No, jump with the relevant points.
Okay. I'd like to direct your Lordships to page 301, paragraph 26 of the judgment, and at tab 9, page 2 of your Lordship's bundle. May I proceed?
Yes, please.
This states that a mere threat of the upcoming torture may at least constitute to at least inhuman treatment and therefore be deemed to be a breach of Article 3. In the instant case, despite the torture not being physically inflicted on the appellant, the fact that the appellant is threatened with the corporal punishment may amount to torture. With your Lordship's permission, I would now like to address my third point of submission, namely that the appellant has a right to the freedom of expression under Article 10 of the Convention. May I proceed?
Thank you.
Article 10 of the European Convention on Human Rights states that everyone has the right to freedom of expression. This right shall include the right to hold opinions and to receive, to impart information and ideas without the interference of a public authority. With your Lordship's permission, I would now like to direct your attention to the case of Handyside, the United Kingdom, as heard in the European Court of Human Rights in 1976 and reported in the European Human Rights Reports 1979 to 1980, Volume 1, page 737. Are your Lordships familiar with the facts of this case?
We've got it here, yeah. Jump to the relevant point.
I would like to direct your Lordship's attention to page 754 of the judgment. The Court held that, subject to Article 10, it is applicable not only to information or ideas that are favourably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock or disturb the state or any sector of the population. In the instant case, although the magazine article was offensive to Mr. Wacker, this case proves that the appellant had the freedom of expression to write the article in its exact nature and is therefore covered by Article 10.
Even though it does represent potential defamation of Mr. Wacker.
On my Lordship, this case was heard before the European Court of Human Rights, and therefore the case is held in a highest regard in the English legal system. Therefore, as the decision was made by that, I am basing my argument that the quote used by the judge in that case.
We'll need to wind you up there, I think,
Yeah.
to move on because of time. So
Okay.
any other relevant points you wanted to make before we
No, Your Lordship, I was
finish
just
with you?
going to sum up my argument.
Probably no need, I think,
No need.
because we've got it. So thank you very much indeed to you both.